What happens when someone needs to secure a debt but doesn't want to transfer ownership of property? That's where security and pledge come in. In this video, we'll break down what these terms mean in Louisiana law and how they work in practice. Under Article 3136 of the Civil Code, security is defined as an accessory right established by legislation or contract. It allows a creditor to tie performance of an obligation to property of the debtor, movable or immovable. This means that all of a debtor's property can serve as security for their obligations unless the law provides otherwise. Article 3133 explains that anyone bound for an obligation must fulfill it out of all their property, and creditors are entitled to share equally in the proceeds if the property is sold. Article 3138 tells us that security can take different forms: suretyship, privileges, mortgages, and pledges. All of these are ways to secure performance of an obligation, but in this chapter, our main focus is on pledge. A pledge is a real right established by contract over certain types of property, granting the creditor a security interest in that property to secure performance of an obligation. In other words, it's when someone offers property, like jewelry, stocks, or even rights under leases, as collateral for a debt. The creditor, called the pledgee, holds rights in the pledged property until the obligation is satisfied. Historically, a pledge required the debtor, or pledgor, to deliver possession of the pledged property to the creditor, or pledgee. This delivery distinguished pledge from other types of security because it ensured the creditor had rights in the property over other creditors. Today, pledges can apply to corporeal movables like jewelry, stocks, or negotiable instruments, and in some cases, incorporeal rights like leases or rents. Article 3142 says only certain property may be pledged, such as movables not already encumbered by another security interest, a lessor's rights in the lease of immovable property and its rents, and things made susceptible to pledge by law. For a pledge to be valid, there must be a contract between a pledgor and a pledgee. The Louisiana Civil Code requires that this contract clearly state the property pledged and the amount of the obligation secured. It also has to be in writing when third-party effects are intended. Article 3141 makes clear, a pledge is a real right established by contract over property of the kind described in Article 3142 to secure performance of the obligation. It only exists because there's a debt or obligation to secure. The pledgee, or creditor, has the right to retain possession of the pledged item until the obligation is satisfied. They may even collect fruits or revenues produced by the property, applying them to the debt. The pledgor, however, also has rights. For example, the pledgor has the right to demand return of the property once the debt is extinguished. When property is pledged, the pledgee has the duty to preserve and safeguard it. If the property is a corporeal movable, the pledgee assumes responsibility similar to that of a prudent administrator. The pledgee must act reasonably, ensuring the property does not deteriorate unnecessarily. The Civil Code makes clear that the pledgee cannot simply neglect what has been entrusted. If the pledgor defaults on the underlying obligation, the pledgee does not automatically become the owner of the pledged property. Instead, the law provides that the pledgee may enforce rights through a sale, either at public auction or private sale, or through judicial process. The pledgee must act fairly and reasonably in disposing of the property, and any agreement attempting to allow forfeiture, automatic ownership by the pledgee, is null and void. For a pledge to be effective against third parties, certain requirements must be met. Generally, a pledge of corporeal movables requires delivery of possession. If incorporeal rights or immovables are involved, The pledge must be made in writing and recorded according to law. Without these steps, the pledge will not bind third parties. Modern law in Louisiana has aligned pledges with the Uniform Commercial Code. UCC 9 governs most transactions where a security interest is created in personal property, incorporeal movables, or fixtures. While traditional civil code pledges still exist, in practice, most secured transactions fall under UCC 9. Under UCC 9, a pledge is recognized as a security agreement. This is a contract in which a debtor grants a security interest in property to secure repayment of a loan or performance of an obligation. The security agreement must be in writing, describe the collateral, and be authenticated by the debtor. To protect the secured party's rights against third parties, the security interest must generally be perfected. This is accomplished by filing a financing statement with the proper office, which serves as public notice. The statement must sufficiently describe the collateral, name the debtor, and identify the secured party. The collateral can be described specifically or by type, provided the description reasonably identifies the property. The filing location depends on the type of property. For example, titled motor vehicles are filed with the Department of Public Safety and Corrections, while other movables or extracted collateral may be filed with the parish clerk of court. In essence, pledges, both under the Civil Code and UCC 9, are tools to secure obligations by granting rights in property. The pledgee must care for the property responsibly, cannot take ownership through forfeiture, and must rely on judicial sale or proper enforcement mechanisms. To protect against third parties, pledges or security interests must meet formality requirements, often through possession or filing. These safeguards ensure that obligations are secured while balancing fairness to both debtors and creditors. Security is about giving creditors assurance they'll be paid, and a pledge is one of the main tools to do that. A pledge ties specific property to a debt, with the creditor holding possession until repayment. Louisiana law carefully balances the rights of the creditor to enforce obligations with the debtor's protections against unfair forfeiture.
This concludes the review on Chapter 17, Security and Pledge, and should provide you with a solid understanding of these Louisiana's civil law concepts. But don't stop here. Be sure to like, subscribe, and hit the notification bell to stay updated when I drop the videos covering more chapters from the fundamentals of Louisiana notarial law and practice. If you have questions or topics you'd like to see covered next, drop a comment below. I love hearing from you. Thanks for watching, and I'll see you in the next video.